So now we can start. It's now 1 o'clock, and we shall start the second session. The second session of our forum is focused on efficiency, building the efficient competition authority from the perspective of its design, organizational design, as well as its authority, as well as practices of law enforcement, as well as the activities of the competition authority for proper implementation of its assignments. We have a representative group of experts in the second session.
Очікую дуже інтересну, ефективну дискусію.
I expect interesting and fruitful discussion. The Competition Authority, the Anti-Monopoly Committee of Ukraine, as we have discussed on the first session, does exist for more than 20 years. We can see that the practical side of our activity actually in its decisions they measure the number of fines charged or economic effect that may reach. They try to measure efficiency in every possible way. That efficiency measurement system must requires development as well as improvement in view of the best international practices. As I said before, last year a decision was taken about 4,500 offenses. Most of them are the ones abuse of the monopoly position. There are countries worldwide where the approach is different from the one which is in place in Ukraine. That monopoly price, charging monopoly price is not considered a violation subject to a review by the competition authority. Worldwide, there are quite many approaches. There is no ideal model of how of the most efficient functioning of the competition authority. Maybe there is one, maybe there is no. There is OECD, which summarizes best practices and develops recommendations for improvement of efficiency. And I'm happy that we shall listen about the experience of other competition agencies, of Victoria as a member of the parliament, as well as position of OECD, international experts. Therefore, nowadays I would like to give the floor to, once again, with great pride, that I have such a co-moderate Mr. Roberto Heindram, who is one of the leading experts in the field of competition law. So, you have the floor.
Thank you very much, Mr. Terentiev. Thank you very much, Mr. Terentiev, and thank you very much for the invitation and also for the honor to chair this session on agency effectiveness. I have one slide just to show for this presentation, so if you can put it on. It would, first of all, I'd like to add to my, no, can you go back? To the list of institutions I'm associated with, also the Competition Development Foundation, where I am advisor to the board, and I'm happy to be here on its behalf. And now, if you can go back to the second slide. First slide. Okay, I have a list of sort of a decalogue, on agency effectiveness. And also the title is important, because a good enforcer is also a credible advocate for competition. So indeed, there are two pillars, enforcement and competition advocacy in all our agencies. But in order to be an effective advocate you have to be an effective enforcer first, because this is where your action is going to be evaluated, and this is where your major mandate lies. And so we start with how to be an effective enforcer. One is that legal provisions have to be sufficiently clear, and the legal standards should be clearly identified with appropriate defenses. And I say this because the EU provisions do provide such defenses. If you take the rules on anti-competitive agreements, there is a defense clearly stated in the European Treaty, which is that technical progress or production should be improved, but a fair share of the benefits should go to the consumer. This is a very important element of the assessment, and it provides a legal standard. The consumer benefit is indeed a legal standard. And the same is true for abuse. Also in abuse of dominance, the EU provision says that we have a dominant company cannot reduce technical progress or innovation if it provides a prejudice to consumers. Or we cannot have price discrimination only if it puts a competitor in a competitive disadvantage. Or we cannot have a tie-in if it's completely outside of the rules of the culture, of the common indications of the commercial practices. So there's always a defense available to companies. And this is very important, and it also goes back to what Ras Damtoft was saying before on procedural fairness, because if you have a defense, you have to be able to argue for that defense in a fair way. And of course, to be an effective enforcer, you need deterrent sanctions, because if you don't have deterrent sanctions, then whatever you do is irrelevant, because of course you can prohibit something, but then if the sanction is not available and it's not a threat, then companies would continue in violating the law. And of course, a law can only be applied if those that have to respect it know what the law is all about. Because otherwise, also it's irrelevant to have a good law that nobody knows, or nobody knows how it is enforced. Finally, we have to have a good knowledge of the law among the judicial. In this particular case, the Court of Arbitration in Kiev should have a common understanding of what enforcing an antitrust law is. But I don't have to say it here, we saw how good Mr. Terentiev is and how expert he is, but you have to have a system where board appointments is of good quality, and you have to have a transparent way of appointing to the boards, which lead, if you have a good board, then you also have a good choice for relevant and important cases that would bring up and boost up the reputation of the authority. But this is really not enough, because in order to, we are an antitrust authorities, and antitrust authority should be, at least in principle, at the same level of prestige in a country as the central bank. There is the central bank on monetary policy. The antitrust authority should be the counterparts of the central bank for the real economy, which means prestige, but also salary for the people, because to be an expert in antitrust, you have to be also attracted by, it's not just the importance of the subject matter, but you have to be attracted by the salary that you receive at the authority, otherwise you leave. You may stay for a while and then you leave, and this weakens the authority. So we need good salaries at the level of the central bank, if possible, and advancement on the basis of merit. Finally, a very important point also is no financial problems for the authority. The financing of the authority is as relevant as everything else I said. And we have to assure that such a financing is coming and that the authority is assured that such financing will continue. We do not want a situation where the authority every year has to fight for its budget, because then all the resources, the human resources, are spent for the budget and not for enforcement. Finally, two more things on enforcement: protection of complainants. If they want their anonymity has to be respected, and they have to know that they don't have a legal responsibility when they complain. For example, government officials in particular, when they report to the authority bid rigging, should be assured that their reporting is no way a responsibility on their part not to have taken action to stop the adjudication procedures or anything, or they have a responsibility with a part of the companies that they should have informed them. So we have to make clear that informing the authority provides no penalty in any way. And finally, the possibility of doing downgrades in companies is very important, and that such downgrades should be unexpected, which is also important, because if they are expected, we don't find anything in such downgrades. Because the companies, when they expect it, have all the time to hide and destroy all the evidence that we may find. So this is a very simple list, and on many of these items, the Ukrainian authority, there is a tick. On others, there is probably something to work on, and I think this represents a good way of going forward. But let me now introduce the next speaker in this panel, which is Sabine Zilewski. She is the head of the OECD GmbH, Hungarian Authority Center in Budapest. She is based in Paris. She used to work for the Bundeskartellamt, and now she's the director of the regional center of the OECD in Budapest. And she's going to talk about the benefits of competition authorities for the economy. So Sabine.
Thank you very much, Alberto. And let me say, is this working? Great. Let me say that I'm very grateful for the invitation, and it's a great honor to speak here to you on behalf of the OECD. And what I really want to do, and I hate to disappoint you, Chairman Terentiev, but I will not talk about all the instruments that the OECD has to offer, because I'm afraid that after 3 hours you would start to leave the room. It will take much too long, but I can assure you that we will be very happy to provide you with all the insights and instruments over the course of the years, and our enhanced collaboration with the MCU of Ukraine, together with our partners, EU and the US. So you will be exposed to them, I promise. What I've brought with me are more or less 2 instruments and hopefully 1 or 2 insights. And let me develop this argument, which I find very compelling. If you think about what benefits competition policy and authorities bring to the economy, then you will have to end up with one conclusion on institutional design, actually. And let me develop this line of reasoning, and I hope that you will follow me in the end. So I'll start with 2 questions. Should you have a competition law because every developed jurisdiction has one? Should you have a competition authority because that's what the donors tell you, that's what the OECD tells you, that's what UNCTAD tells you, that's what World Bank tells you? No. Certainly that's not a good reason why you want a competition law enforcement system and an authority. What's a good reason? Because you want to have a competition policy law and authority because they enable, they support, they create, and they foster what we're aiming for. And that's basically increase in economic welfare. So we want to make the pie bigger that we then can share instead of just making do with a small slice of the cake. So we want to have the pie bigger, and how do we do that? Well, if we open up markets to competition, we will increase productivity. Recent and very robust World Bank study shows, and that was made for Eastern Europe, if we open markets to competition and if we maintain competition on these markets, then we will gain productivity increases of 12 to 15%. That's conservative values. That's real. Productivity increase will increase growth. That's what we're after, GDP. with that comes employment. So we might have short-term frictions and employment losses, but in the long run, that is also beneficial to employment, and it will also help to foster equality. Because A, we have more to share, B, if powerful market positions are being eroded, then we put a stop to redistribution of wealth from the poor to the rich, and these are the ones who are in powerful positions. So we can also work on our equality goals. Competition also is about fostering and incentivizing trade, open markets, making national domestic firms fit for competition on the international markets. That benefits our economy, again increases productivity. Trade is also another condition for really making these markets open, and it will also attract and incentivize foreign direct investment. So competition does a lot of things, and this is not just guesswork. We have a lot of robust evidence and studies on this, and this is one of the instruments I would really like to give you, or maybe more information than an instrument that you should use in your advocacy work. We have the OECD fact sheet 2014 for you to have on the internet that gives you a line of reasoning if you have to sell what you're doing, why it is important to have a competition authority and a good and pervasive competition system. So as Alberti said, it's a two-pillar system. First of all, competition authorities enforce competition law. That's extremely important. Secondly, you advocate competition law on the government level because policymakers, they have to make sure that there is deregulation, that we incentivize managers, that we have free trade and so on. So this will lead to more competition in the markets, productivity grows in general, GDP grows, more wealth to be shared. This all means that competition is not a thing that you're done with once you have created a competition law and a competition authority. So you tick your box as a state and that's it. No, it is an ongoing process. So what you need, it's a mindset. It's a mindset. It's a concept. It's a way of living and of leading an economy. So we need a competition culture, and that has to be pervasive in each and every policy area. And that is what you need a competition authority for. Your competition authority, that is your permanent good or often bad conscience. You are the ones who have constantly to remind policymakers why it is important to have competition. So you are the ones that raise their voice, even if no one wants to hear that. And that will be the case very often because you are uncomfortable. You are speaking up against the protection of domestic firms. You're speaking up against protection of employment by way of subsidies, by way of allowing anti-competitive mergers exceptionally. You speak up against the undue protection of state-owned enterprises. You speak up against restricting licensing, zoning schemes, against anti-competitive laws and regulations in general. And from this flows that it is very obvious that competition authorities, their chairman, their management, they will not be loved by everyone. To the contrary. You face a lot of enemies and opposition, and that is what makes your job hard. But it is your job to be uncomfortable. It is your job to spoil the fun. It is your job to make everyone work harder, think twice. And that is hard work, that is uncomfortable, that is at times cold, it's always challenging. And I think from this, and I hope you can follow me here, flows quite naturally that there is one necessary condition for a competition law and system to work. You need an independent authority. Because if you are not loved, to the contrary, if you face constant opposition, if you're constantly uncomfortable, then constantly there will be an incentive to interfere with your decision making. And this should not happen. And this can only be prevented if you're independent. So independence has a lot of dimensions. So you have to be safe from outside intervention in your decision making. Independent decision making. You have to be safe from sudden withdrawals of your chairperson or your management. And we see this all over, not just in Eastern Europe or in these developing jurisdictions. We see this in our OECD jurisdictions quite recently, a number of examples. You have to be safe from sudden budget cuts, from staff reductions, because otherwise you can't do your work, and you have to be sure that you will retain your staff and that they're decently paid, as Alberto said. That is really a very relevant condition. So in short, I think if we want to achieve all the benefits of competition on a long-term basis, if we want authorities to be our bad conscience, then independence is a necessary condition. It's not a sufficient condition, but it is absolutely necessary.
Indeed, Sabine, thanks a lot. It's very much is resonating with our ideas about how a competition authority should function on the principle level and also on the practical level. Yet we, in our position, we are a bit more than, not even a year, yeah, so a bit over half a year. We are striving to live and work up to these high standards, and really appreciate a lot intellectual support which we get from OECD with all results of all 163 roundtables on practical topics, which we basically, and this is true, which we use in our daily work. So this is a very good source of information for us. A bit developing on what you have started with, how would you say, what would be your suggestion, for example, to if you have in mind launching and designing a system to evaluate the impact of activity of competition authority or some specific interventions, do you have some best practice or advice on that with regard to approach which we need to take?
Thank you. What a surprise. Yes, I have. So let's get down to earth a little bit. Let's talk money, because that is an argument that even policymakers understand. So I apologize to all policymakers in the room, but sometimes it's as simple as that. Meaning, if we want an independent competition authority, it doesn't mean that it shouldn't be held accountable. And accountability has a lot of dimensions: reports to the government, ex post assessment, of course being subject to appeals to independent courts, to court review. But one very basic thing could actually be that you quantify the impact of your work. So we just want to show, and maybe that's a language, as I said, that policymakers understand, and also our citizens and our businesses, that we are a good business case to have. That if we were a publicly listed company, you would want to buy shares in us. This really helps, and we have some instruments here. So I want to focus a bit on quantification of competition authorities' interventions, and the OECD has done a bit of work on that in 2012-13. We've done some stock taking. That's what we usually do. What are actually the best practices of our members and also other countries that have interesting ideas? And this led to, or the rationale show that you earn your money. And many competition authorities do this on a regular basis. The UK CMA, the US agencies which are in the room, of course, do this. The EU does it. The Dutch competition authority does it. I know that Lithuania does it as well, right? And now you might again say, well, I mean, come on, get real. We have heard what the AMCU is coping with. On top of this, should we really try to figure out what the benefit for our consumers is, for our economies? Isn't that asking a bit too much? This is so resource consuming. This is so challenging. I mean, come on, this can only be done in exceptional cases. I say, no, that's not true, because actually it is quite simple to do. And we suggest, and again there's guidance from the OECD on this, a very easy to use, a very hands-on methodology that you can do with the figures you have. No extra work, I promise. So it basically means you turn to your, well, 3 bread and butter areas of enforcement: cartels, mergers, abuse proceedings. And that's an assumption we make, and that might be bold, but that's one of the assumptions we do, that actually if we intervene, if we enforce, then this is beneficial. This was good enforcement. Let's hope that this is the case. And then we calculate the benefits of the enforcement. And what do? Well, we assume that every merger prohibition or remedied merger prevents price increases. We assume that every cartel that we have bust that is now out of the market will again lead to price decreases, so benefits to consumers. And the same for abuse proceedings. If we stop an abuse, there will be a reduction in prices. We assume it has led to price increases. How do we do that? Well, we have all the numbers we need for mergers. If you have done a proper investigation, and I hope you do that if you prohibit or remedy a merger, we should know about market volumes. That's the number, we have it, ex-ante numbers. If we bust the cartel, well, we know about the turnover of the cartelists. That's one of the numbers we should have. Same for abuse proceedings. And then we basically, and that is based on the experience, of jurisdictions, also on economic studies, and these are very conservative numbers. And you will find this in the OECD guidance that is there. Conservative approach would be to estimate the cartel overcharge at 10%. Beneficial effects from abuse proceedings, a 5% price increase that was prevented. For mergers, we would suggest something around the area of 3%, and then we assume that this was beneficial for a number of years, 3 or 2 year duration. These are conservative percentages. It's the lower bound. You're safe here. This is also conservative because it does not take not account of the deterrence that your action has. So how many other anti-competitive mergers will not happen? How many abuses will be stopped? How many cartels will cease their existence or will not be created because you have actually been a deterrent force on the market? And it also does not account for dynamics, so not for the effects on productivity and innovation by having improved competition on markets. So it's a lower bound, and the beauty of it is it's actually true. And then you compare the values that you calculate per year or on a 3-year moving average, that's probably the wiser choice, to your budget. And guess what? As most competition authorities have rather small budgets, I can assure you, you will be in the positive. So this is really relatively easy to do, existing numbers, conservative estimates. And I mean, I don't want to spoil, I assume that Sharunas will be mentioning what they do, but I know that they have an amazing ratio of consumer benefits to competition agency budget, but you might want to talk about it yourself. So I'm not going to take it away, but I have looked it up. Just one example, assume we have a merger case. We have prohibited or remedied the merger and the market volume is 200 million euro. That's not much, right? We're talking about market volumes. So 200 million is not a big number. But if we just use this, and then we assume, again, prevented price increase, 3% benefit for 2 years. That brings us an estimated consumer benefit from this one merger prohibition or remedy of 12 million euro. 12 million euro covers the annual budget of the competition authorities of Finland, Brazil, Israel, Denmark, I'm sure of the AMCU by far, and by many other many other smaller competition authorities. And so I would say that you're on the safe side if you try this exercise. It is relatively easy to do and you shouldn't be afraid. And if that's what your governments, what your public needs, if they have forgotten about all the other much bigger benefits to productivity, growth, employment, equality, then please, on the side, use these numbers. They can be pretty convincing.
Sabine, thanks a lot. You were very generous about estimating our budget, so unluckily it is even below $3 million, I would say. Indeed, the methodology which OECD is employing and suggesting, we have been aware of it, and the point is that how to translate it into really actionable guidance for not only for Anti-Monopoly Committee as a central body, but also for the territorial branches. It is indeed a challenge to convey these principles in a very streamlined, simple, understandable idea, which would also serve as a practical daily tool, helping territorial department to prioritize one case over the other, basically based on the criterion of estimated economic impact. This is something which was a topic for specific discussion once when we had a meeting between anti-monopoly committee and the heads of territorial departments, because our idea is that we should really eradicate the practice of quantitative results based on simply number of cases resolved or number of penalties imposed, because this is not actually the reason why we are here. Our reason is not to proliferate number of cases. Our reason for existence is to bring positive economic impact. And in this regard, I would like to, I will now, я перейду тоді на українську. Тому я б дуже радий, що в роботі нашої колеги, в роботі нашої
Our panel, our second session, is attended by Victoria Ptashnik, a member of Parliament of Ukraine. She is very well known to the lawyers, as well as business circles, political circles, as an expert in the field of competition law, and also one of the most active advocates of development of competition in the transparent European direction. So, Victoria, I would like to ask you, as you assess what was mentioned by international experts, how would you assess the current preconditions, prerequisites for ensuring efficiency and functioning of the competition authority in line with that set of authority as well as status the competition authority currently has? To your mind, is it an optimal decision, or you as a legislator have any plans or ideas you would like to share with us? So, please.
Дякую.
Thank you very much. I'd like to apologize that I have to leave earlier from this panel, but still I'm very pleased to be here with you at this forum. Just like at all previous forum, I'm very grateful to the organizers that this forum exists, and it promotes competition policy in the country. I was listening to the previous speakers, and I remembered the coalition negotiations before at the beginning of functioning of this parliament, when people applied to me, Georgian experts applied to me, and then they advised what should be done about AMCU. And then they came and they said, let's liquidate AMCU, just like we did this in Georgia, because we don't need it. Your market is not so big, and so on and so forth. But we decided to take a different way. We decided that we need to put in place new principles in operation of AMCU. We need to change legislation, competition law, so that the way different international agencies do is like OECD in 2008, they recommended this to us. We need to review this report of 2008, and despite the fact that so many years passed, finally we need to put in place this report now. Regarding the agency itself, the competition authority, the main principle of functioning of competition authority is independence. Independence from political forces, from public agencies. AMCU is unique agency. It has special status guaranteed by the Constitution and other laws, and we cannot change the status. Also, I'd like to draw your attention that unfortunately not all members of parliament have the same idea, because at the parliament the bill was registered that proposes to change the special status of AMCU and to strip AMCU of this special status and to remove some provisions from the laws, so that AMCU, as I understand it, will be turned into controlled body, controlled by the ministries or by the cabinet of ministers. I think this should not be done. This is not acceptable. I'm glad that standing committee which reviewed the bill recommended to recall this bill to the authors, to the developers, because it violates all the principles of all competition authorities globally. At the same time, for AMCU to provide full independence, and this is just as important to provide the principle of collegiality in decision making. We can introduce some amendments to legislation on the procedure of appointment of the chairman of AMCU and state commissioners. Our procedure is that the Prime Minister suggests the candidates of the chairman to the Parliament approves the chairman, and then they appoint all the rest of state commissioners based on recommendations of the chairman. And the final appointment is carried out by the Prime Minister. I submitted my proposals to the Constitutional Commission, as these issues of appointment of chairman of AMCU are regulated by the Constitution, and as soon as Constitutional Commission will be able to start dealing with these issues of rethinking the redistribution of these powers and the power triangle, and go back to this, I believe that it's very important to provide the collegiality principle. We need all appointments of all state commissioners to be made in the same way. In particular, if the Parliament of Ukraine approves all state commissioners, not identifying who is the chairman, who is the first deputy, and after that, the state commissioners, the way it happens in the courts, can independently elect the chairman. I believe this principle institutionally will be more effective basis for collegiality principle. Personally, I believe, I see it in practice that, thanks God, finally the composition of AMCU can vote differently, that we don't have the situation when all state commissioners look at how the chairman votes, or there is some other motivation. There is discussion, and this principle of collegiality has practical implementation, but institutionally I would consider how to improve it, to separate it from personalities, so that once and for all, regardless of who is the chairman and who is the state commissioners, so that this principle is effective. As regards the plans and legal initiatives, we discussed that in order to develop competition, it's extremely important not just to have the fact of investigations, bring into responsibility of infringers, infringing entities, but also the most important issue is implementation of the legal framework. And the decisions of AMCU should be fulfilled by the entities, and the way the entities respond to the decisions of AMCU, and if they really stop their infringements, it really defines how competition develops and economy develops. So, I would like to raise one more issue, which is the short-term issue, is the jurisdiction of disputes in the courts of Ukraine. At the moment, based on judicial reform, what we discuss is the idea of new commercial procedural codes. And the commercial procedural codes, the issue of jurisdiction of antitrust litigation should be identified. At the moment, there are two approaches. One of them is to keep all the disputes at the commercial courts, although at the moment we really have some collapse in legislation, as legislation in Ukraine allows to have the jurisdiction in both commercial and administrative courts. But at the same time, the practice is the following. Most cases still are heard at commercial courts. So the first approach is to keep all the cases at the commercial courts. The second approach, which is discussed in the framework of judiciary reform, is that the commercial courts should hear the cases in the area of unfair competition. And they explain it that these disputes have commercial component. All the rest of the disputes on complaints, on abuse of monopoly position, anti-competitive concerted actions, permits on concentrations or failure to fulfill the decisions of AMCU, all these cases are proposed to be heard at administrative courts, because administrative courts have powers to hear cases with the public agencies. It's obvious that AMCU is the public agency. It has powers of the public agency. It's very debatable, it's very controversial in my view. On one hand, AMCU is the entity which performs the functions of the public authority, but at the same time administrative courts have no practice to hear these cases professionally. At the same time, it's the question of who will be responsible to provide proof in these cases. In the commercial cases, the entities have to prove their rights. In the administrative cases, the burden of proof will be on AMCU. And the question is whether the judges and administrative courts will be ready to evaluate the decision made by AMCU, not having this practice, to effectively enforce this decision. And next question, do we need to distinguish these disputes between different courts, commercial and administrative courts, will be efficient? So I'd like to invite you for this discussion. It seems to me that separately we need to hold the round table and to hear the views of experts on antitrust law, so that this reform is efficient, so that members of parliament will not make mistakes. They should make the decisions which will promote competition development and effective implementation of the decisions or bona fide decisions of AMCU. Thank you. Thank you very much, Victoria, for this position, which is sincere and targeted at development of efficiencies and functioning of AMCU and functioning of the system to stimulate the development of healthy economic competition. We have great experience of cooperation in legal drafting, and we're ready to support the bills targeted at reaching the objective of reinforcing the independence of the competition authority, to increase the transparency of AMCU functioning. And as regards the issue of court hearings, we're interested in legal certainty. Every model that is discussed has its advantages and disadvantages, some inefficiencies as well. The best way to develop and to agree the right decision, the correct solution, is to have the dialogue in the expert community, to involve AMCU and legislators, and we're ready to participate in this dialogue. And if we encourage the initiatives to hold this dialogue. Coming back to legal initiatives, besides the issues that you raised, do you have any other issues that, in your view, require legal settlement, legal regulation. Maybe you work on something personally, or some other MPs are developing something on our topics of competition. First, I believe that I'd like to greet all the participants that the President finally signed the bill that we adopted yesterday. The President signed the bill on enhancing of value indications on concentration cases. This is what OECD was telling us in 2008 when we started this discussion in the Parliament. Honestly, I did not believe that we will get this outcome, and after so many years of work, you know that earlier we had the bills that were adopted to increase the value indicators in the first reading, but the Parliament unfortunately failed to adopt the final decision. Finally, the President signed the bill. It enters into force in 2 months after the publication of the bill, so AMCU will be freed from the cases on concentrations which had no impact on competition, and it will be able to focus on the most important cases that really influence the competition. Also, the bill was adopted on publication of decisions of AMCU, and it was also very important to envisage this balance between information which AMCU can publish and disclose in order to be transparent, and information with limited access that entities close. So how to strike the right balance so that entities do not close all the information that is not confidential, and the disclosure will not lead to any impact on competition relationships. So I hope that with these bills we'll have some small share reform of competition law that we already have. Regarding our next ideas, I believe that we need to start making amendments to the procedure of review of cases on infringement of the law on economic competition protection. Today, this procedure is envisaged by the resolution approved by MCU itself in 1994. I believe that this resolution is outdated, and there are principles that should be changed, and we need to improve the idea of competition that we have. The competition in the court, competition of parties in the court. We should have the same competition of parties in the MCU when we hear cases on infringements. You know that MCU is quasi-judiciary body. Also, according to association agreements, we have the obligation to provide effective protection of rights of entities which participate in infringement cases. So I believe that this extremely big tier of work is huge work, but at the same time this is very important, and we have to make this effort jointly with AMCU and legal markets and entities and business associations. Altogether, we will develop new procedural rules for the transparent procedure of investigations and implementation of legislation. Thank you. Thank you very much, Victoria. AMCU has ideas on protecting the procedural rights of entities. As part of cases review, we are ready for public discussion of this document, both conceptually and practically, because we had many proposals on drafting competition procedural document. Some people said we need to create the code, to develop the code, or to fix it in legislation, to fix the procedural mechanisms or procedural obligations of the procedure to review the cases. I'd like to move to Russian for Viorica. Viorica, I have a question. When we smoothly move from our ideas and plans on drafting effective procedural provisions on competition, tell me please, what is the practice in Moldova? As far as I know, you have some developments in this issue. Can you tell us about this? Can you share? Thank you very much indeed. First, I'd like to congratulate Mr. Chairman that in person of Victoria have a vivid example of advocacy, and I wish you to have as many MPs as possible who understand what is competition law, and who support you in your initiatives. This is very important indeed, because you know why it's important, right? If we talk about effectiveness of competition authorities and procedures, last year in Kiev, I was talking about economic indicators that we have to set and achieve for ourselves to have effective operation of competition authority. Today, I like to have different approach because many factors influence the efficiency of competition authority. I'd like to discuss procedures. Sufficiency or insufficiency of procedures, how they're specified, how they're applied, because their implementation defines the results of our activity. If you look at the slide, let's make the claim for the victory and discuss the notion of competition procedural law. I know that many lawyers, most of the lawyers in this room, many lawyers must have been thinking about this. For some lawyers this is something new, but I think it's the right time. Maybe we should start discussing this topic, as competition law were between administrative law and civil law. We use the procedures, and if we talk about material competition law, in most countries it is synchronized. We have the same infringements, we have abuse of domination, we have M&A, we have cartels and so on. If we talk about procedural aspects, it is completely different. And I believe that every participant will say that in each country it's insufficient, especially we will not ask lawyers, but if we ask lawyers, they will support it. And us as representatives of competition authorities, we feel the lack of developed procedures, well-specified procedures. In theory, I don't want to pay a lot of attention to this. We gave the definition of competition procedural law. This is only for discussion. These are our developments for discussion purposes. We're talking about principles. Of competition procedural law. I think it's the subject for a separate roundtable in Kiev, Chisinau, or Singapore. We can discuss it at ITN or anywhere else. This is the topic for discussion. If we start today, we need to spend some time with the idea. Some people will support it, some people will be opposed, but we have to discuss it anyway. So I'll not discuss principles or elements or theory, background. I'd like to say that competition procedural law is enforced by separate bodies. These are competition authorities, so it's especially important for us to set the clear procedure, clear sequence, clear conditions and terms. This is obvious to all of us. I know that there were attempts in many countries to create the competition code. I know that in Ukraine you had this attempt, but you don't have the code at this point. We had this idea as well. Azerbaijan had this idea, some other countries as well, but the drafts that were created, they had only partial coverage of the procedures. So second idea, I'd like to focus on two ideas. These are ideas for consideration. First is competition procedural law as the separate area of law. Let's discuss it. Let's think about this. And second idea is the common matrix of procedures. I'd like to show it to you. This is what we need to start working on. For the lawyers, the matrix doesn't mean anything, but we're used to this. This is the table in which we can see that. Horizontally, we can see all the infringements we talk about. They're almost unified. And vertically, we try to have the breakdown of competition process into phases, stages, and so on. If we talk generally, we have 3 phases. First phase is investigation of cases at competition authority. Second phase is judiciary review. And third phase is enforcement. These are 3 phases. Each one is subdivided into stages. First phase, we can talk about first stage preliminary investigation. I know that now many countries which targeted their laws, modified their laws according to EU standards, again in material norms, material provisions, we have the same trends, and procedurally we have large procedural blocks that are the same. We have the stage of preliminary investigation, which can finish with initialization of investigation, or it may finish with not starting the investigation. Next stage, second stage, is investigation carried out by the executive officers. It's the group, the team of lawyers and economists that deal with investigation directly. And third stage, which we discuss here, third stage is investigation under the auspices of plenum. In Moldovan law, we separate executive power from plenum, which makes decisions. As far as I know, in Ukraine it's almost the same, with some deviations, with some specificities. At the second stage of judiciary review, again we have 2 stages. We have first instance and appeal. In Moldova, we don't have specialized courts, even commercial courts, not talking about specialized courts. We don't have specialized judges in competition law, so our decision is mandatory for enforcement. Sometimes we act as almost first instance, but our decision is compulsory for execution. If it's not enforced, it goes to the next stage. Then we have 3 phases, so each phase is subdivided into stages. Each stage is subdivided into steps. This is vertical breakdown, and horizontally all this is different for different infringements. We cannot say that we have the same procedures for unfair competition and procedures for M&A. They're completely different. They're completely different for abuse of a dominant position. It's similar to cartels, but again, the procedures are different. It's good to think about this topic. It doesn't matter how we call it, what's the final product, but we need to start thinking about this. We need to start developing the procedures. We need to start having this matrix. We need to have diagonal, not only vertical and horizontal in this matrix. The more is the level of detail, the easier for us to operate. The higher is the development of the country, the better are all provisions specified, and the better is the quality of this specification in the provisions. Without well-established procedural law, in Moldova we tried to specify it in the law, we tried to cover many procedures, we tried to produce rules of procedure, regulations, if we couldn't fit something in the law. In the regulations we see a lot of drawbacks when we don't have the procedures. What the competition authority does, they issue some internal regulations. Many colleagues have 1,000 or 2,000 pages of internal regulations, then they are confused. They start from the beginning. It's the ongoing process of development of our activity. In principle, it has direct influence on our efficiency of competition authority. At the end, I'd like to say that without well-established procedural law, we cannot arrive to democratic system. Well-established procedural law gives the right for protection for economic operators, which is the important part in our legislation and our rights. And well-established procedural law, procedural competition law, is the guarantee for the rights of freedoms of business, which is also extremely important in EU acquis and also in our legislation in Moldova and Ukraine. These 2 points that I wanted to cover, I wanted you to take home and to discuss these, maybe here today or at the next meetings, pros and cons and some advantages and disadvantages. I'd like to repeat that we're talking about competition procedural law and common matrix of procedures. Thank you.
Chair.
Thank you. Дуже дякую. Я думаю,
Is quite important because due process is necessary for does it work? Yeah, because due process is necessary for competition law enforcement, because with due process we understand the restriction better, because we confront the parties with what we found against them, but parties can defend themselves, and that defense is extremely important for understanding the infringement itself. And going back to the court system, I'd like to say that in Europe we have many systems. We have specialized courts, we have administrative courts, and we have commercial courts. But what I think is necessary and essential is that the judge is always, or more or less always, the same, in the sense that we don't change judges all the time, since cases, in our case of Italy, for example, or in Europe, are very few, and therefore we need to build competence with a judge. And even if it's an administrative court, it's fine, but that administrative court have to use the same section all the time to deal with antitrust cases. I think that's essential for a correct application of the law, because it builds competence on the part of the judge, that if he hears a case once a year and then he will hear it again 10 years after, there is no investment that he will make in understanding the law. So we need to build some professionalism in the judges itself. If we don't have a commercial tribunal, we should have a normal court, but the same section should deal with antitrust cases. I'd like now to move to our next speaker, which is Šarūnas Kerezauskas, the chair of the Lithuanian Authority. And he will speak of being an effective agency and how we can show this. And so we will come back with some ex post assessment with his presentation. So Šarūnas, you have the floor.
Thank you, Alberto. Is it working? Can you hear me? Yeah. Thank you, Alberto, and hello, everyone, again. Yes, I'll be speaking about 2 things, how to be efficient, effective agency, and how to show it. Why effective? It's increasingly difficult these days to be ineffective, because the demands of population keep going higher and higher. Demands of your staff are also higher, because especially younger people, they need to be kept excited. And if you're not effective, that's not exciting. Then you have people leaving your agency. So there are incentives to be effective. And of course, we want to do good things to the society. The challenge here is, how do you measure effectiveness? And how do you show it? How do you explain it to the public? I'll deal with both very briefly. I'll start with measurements. And quite helpfully, Sabine has already introduced the concept of how to measure effectiveness using the so-called ex-ante model based on certain assumptions. So here, we've been using this methodology. Initially, it was the OFT, the Office of Fair Trading in the UK methodology. Now it's the OECD methodology, quite similar. The basic thing in it is to measure what benefit the intervention of the competition authority brings to consumers. And as has been explained, the calculation is based on certain assumptions. So I will not go into detail. Why using this methodology and at all? Well, there is an old way of measuring your effectiveness. You can count the cases you open, the cases you close, the amount of fines, etc., etc. Something that Yuri has mentioned in his comments. But people are not interested in that. That's not why we're here, not because of the fines, not because we want to open more cases. Because whenever you present these things, people may be excused if they ask, so what? What's in it for me? That you had 1,000 cases or 10 cases. So we do measurement. Perhaps I must say from the point of view of the competition authority that uses the methodology of the ECD, the methodology is not perfect. Far from that. Nobody claims that, not even the OECD. And of course, when using it, you'll hear critics saying, well, look, but it's based on assumptions. You're not actually assessing the real impact of your interventions. The methodology is pre-programmed to find benefit to consumers, regardless of what happened in fact, and so on and so forth. Well, all that is correct, but as a way of thinking, it's still valid. And when you're asked the question, well, how to instill this into the minds of people working in regional offices, I think it's not that different from what companies are doing. If you're producing and selling one product, you always have to think, maybe I would earn more by producing and selling something else. So if at least one way of assessing your performance is what benefits you produce to consumers, then people would think twice before going after some insignificant case, and maybe they would stop and think, well, there are some bigger problems in the market. Perhaps I should open and investigate another case. It's more difficult, but perhaps it's more relevant to consumers. Again, we will never achieve mathematical precision here. It's not about precise numbers, it's about the way of thinking that either we bring benefits to consumers or we don't care about it. We do care. The acceptance of those numbers in the beginning will not necessarily be warm. I remember several years ago when we started doing this, some members of parliament laughed. That's okay. At least we made them laugh. But I remember already 2 years ago when we presented our annual report to the Economics Committee in the Parliament. One member of the committee was using language of this methodology. So we made them think this way, however imperfect it is. But still, that's the way to analyze our performance. And because then, if you do this every year, you can compare, you can see whether your priorities were right, and so on. One thing to remember, of course, is, unlike in business, it's not all about sales and profit. Sometimes you have to open and investigate cases because they have strategic significance. The markets may be small, but the findings of your investigations may be very important to clarify some legal issue for businesses that is not clear. So it's not all about benefit that you can calculate. So that's one way to assess. There is a better way to assess, but much more difficult. That's so-called ex post assessment. When you actually go into when you go into actual effects of your interventions, it's a scary thing because what you may find is that there was no benefit at all, or that most likely it's very difficult to measure because you need so much data that basically you're stuck at the very start of the process. So I would say this is something that only large and authorities with huge capacity can afford. It's a luxury good. It's nice to have. But before getting involved into this exercise, I think we should all think very hard, because it's not easy, I can tell you that. We have a certain internal rules for that, but we never applied them. Question why? That's measuring effectiveness. How do we show it? Because sometimes we tend to believe that if we do good work, that work will somehow be evident, self-evident. Not really. Probably you, in many cases, still find, or you have already found, that many people don't even know our existence as authorities, or they don't care much. So it's our challenge to explain. Because whatever measurements you will produce, again, people don't care that much about numbers. What do they care about? I remember one episode from writing my PhD thesis, and I came to my supervisor and I told him, look, I'm about to finish my PhD, but I have this problem. I saw other PhD theses, especially from France and Germany. They spend so much time on writing about objective and methodology, and they classify, reclassify, and they do proper science. Should I do this? I did my PhD at King's in London. Well, he said, no, you shouldn't. What is important is to have a good story to tell. A story that people understand. All these methodologies, classifications, reclassifications, okay, you can do that, but that's not something that people really understand. Maybe you will be addressing a niche of 10 people. So the same for us as Commission authorities. We have to have a good story to tell. It's not easy. First of all, you have to have a good story. Sometimes our investigations, when you're critical and you look back into your own history, and you think, well, was that a good story? How can I explain to people, to my mom, why we intervened here? What happened because of that? Or how consumers were better off? Well, perhaps that was not a good intervention if you can't tell a story. Then, of course, you need to tell it, and you need to be able to tell it so that people understand. If telling good stories was easy, then probably we would not see so many terrible films and books being in theaters and libraries. It's a difficult thing, especially for people like me, lawyers. Normally people have an image of lawyers as someone who lack imagination. And telling stories, putting complex antitrust issues into plain language that people understand is incredibly difficult. So what is a good story? Well, the good story is you have to identify a problem that people find relevant, and you have to present how you fix that problem with your intervention. Good stories are about products that people care about, like cinema tickets, how expensive they are, food products, because people have to buy food, how much petrol costs in a petrol station, and so on and so forth. And if you intervened, how things changed after that? Well, it's not easy. And sometimes you also have not only to tell a good story, but sometimes you have to tell a bad story. That is, you have to tell, for example, as we did last year, you have to tell the dairy farmers that the reason that they are unable to survive market fluctuations is not necessarily because some conspiracy theory, but because 74% of dairy farmers have no more than 5 cows. They simply cannot function in a modern dairy market. that's a very bad story to tell. We almost received threats from the farmers to come and to have a protest in front of our offices with cows. Luckily, there is a government that is being held more responsible for the situation, so I think the cows will go there. But that's example of bad story. And still, you have to be able to tell. Anyway, whatever story you tell, a good story or a bad one, tell the truth, because that makes life easier.
Thank you very much. I think one of the most important objectives by doing ex post evaluation, even in an ex ante way, is to guarantee the funding of the authority. I think we discussed before in agency effectiveness is very much related to the financial sustainability of the work of the authority, and this type of assessment is extremely important to promote the authority and to guarantee its budgets for the year and for the future. Both, even in an ex-ante way, I agree with what Sarunas was saying about ex post. I'm not going into the detail, but of course, ex-ante, you can show what you have done, and especially if you do important cases, relevant cases that address important parts of the Ukrainian market, then of course you can show big benefits. And of course you need a story. So I think this provides us with some clues on how to go about and strengthen the reputation of the competition authority internally and externally, which is quite important because we rely on government funds in competition with other agencies and with other ministries, and the more we show, the greater amount of funds that we are able to receive in return. I'd like now to move to the next speaker, which is Michael Mikulic from the Czech Competition Authority. He's the vice chairman of the authority Brno. And he will discuss international cooperation and the experience of the Czech authority, both with respect to multilateral organizations like the OECD and ECN and ICN, but also with respect to bilateral cooperation with other agencies, I imagine, in Europe. So, Michael.
So, thank you very much for your introduction, and thank you very much for having opportunity to speak in front of this audience. So, instead of speaking in general about cooperation with some international platforms or cooperation with other NCAs, I'd rather touch some examples and difficulties we had to face in terms of this cooperation and try to explain how cooperation with international platforms, as you just said, OECD, ICN or ECN, contributed to legislative works in our country. So we of course draw on experience gained during such collaboration in the following respects when I'm talking about international platforms. First of all, legislative works. It concerns primarily Czech Competition Act and soft laws issued by our agency. And secondly, we are convinced that such international collaboration contributes to the convergent and effective enforcement of competition law not only within EU but in much broader sense. So, in terms of legislative works, I'd like to mention two cases. Before we joined EU in 2004, we took inspiration from ICN soft laws dealing with mergers, and in particular we adopted a local nexus to our Competition Law Act. So before that time, the worldwide turnover required for mergers assessment was 5 billion Czech crowns. However, there was no connection to the Czech Republic, to the geographical scope of Czech relevant market, which no doubt it was quite weird. So after, let's say, 2 years more in-depth analysis, we lowered this turnover from 5 billion Czech crowns to 1.5 billion Czech crowns. And at the same time, we stated that at least 2 major parties must achieve their turnover on Czech soil, and it must be more than 250 million Czech crowns. So, and since the time, this threshold hasn't changed. So I think we got it quite precisely. Consequently, the number of measures we scrutinized dropped from roughly 200 per year to no more than 50 or 60. The second example is of legislative works is introduction of leniency program and settlement procedure. In this case, we took inspiration from soft laws issued by Commission. We introduced it into Czech Competition Act in 2012, and as I said, leniency program and settlement procedure applied at the European level serve as a basic model in basic elements. However, we tailored it to Czech legal environment, judiciary, and consequently the settlement procedure a little bit changed, so it doesn't serve as a not only, it does serve only or solely as an investigative tool, so it's not to achieve procedural efficiency. Why we actually did this, before 2012 we applied leniency program, however it existed just in the form of soft law. And there were some doubts whether such a state correspond to the constitutional principle of legality, under which state power can be exercised only under the law, under the acts. So we are convinced that it was the adoption of these two principles into Czech legal system contributed significantly to the legal certainty and raised the level of legal awareness. Of course, we are always issuing soft laws, and while doing this, we are inspired by ICN, OECD, or the ECN models. So we've got Czech de minimis notice, which is more or less the same like EU minimis notice, guideline on the method of setting fines. We change the Czech legal system as well, and so on. The second question, or second part, related to Czech experience in bilateral cooperation with other competition agencies. I'm going to. It doesn't work sometimes not. I'm going to mention two cases, two practical examples and difficulties we had to face. Once, just a few years ago, we were asked by other NCA from EU member state, in particular Latvia, to undertake inspection in headquarters of one undertaking on Czech soil in Prague. We received a request for cooperation under Regulation 1, Council Regulation 1/2003. However, there are some additional substantive requirements under Czech laws which are not included in that regulation, and one of them is that there must be permission for that inspection site by a chairman of our office, and the permission must include some requirements, and these requirements weren't included in that request. So we asked our colleagues to put it in, so that in case of judicial review before Czech courts, we could stand the test of this judicial review. So otherwise, that inspection should be regarded as illegal, or steps performed during that inspection as well. Second case is request for information from undertakings with headquarters abroad. Again, if you are dealing with case having EU dimension, either breaching Article 101 or 102 of the treaty, regulation, Council Regulation 1 from 2003 is very good legal tool. However, there are some cases having no EU dimension, or you are dealing with competition authorities not being member states. What to do in such a case? So you must apply merely domestic competition or national competition rules. And you must rely on willingness of domestic NCAs to provide you with such request of support. So far we face no difficulties, however business is getting global very fast. The number of NCAs tripled within last 15 years, and we expect difficulties may arise in the near future. So we are amending Czech Competition Act. It should, we should have power to conclude international treaties, either bilateral or multilateral, with other competition authorities about such cooperation, and we are quite convinced that such treaties could facilitate this cooperation, specified, put more light on that cooperation, and such a provision in our act lie down legal basis for such cooperation, since a concluded treaty becomes the part of Czech legal system, and parties to the procedure will hardly successfully claim in judicial review illegality of procedural steps made by our office, as an example, unlawful collection of evidence or making unlawful downrate, etc. So thank you very much.
Okay, thank you very much, Michal. We are a bit over our time, but I think we'll be try to speed up a bit and finish to compensate the delay which we had of 15 minutes in the beginning. Very pleased to address now to Hakan Karakoç from Turkish Competition Agency. Basically, the topic which comes in discussions about effective improvement of effectiveness of every competition authority is the proper separation of duties between competition agency and sectoral industrial regulators. This topic is relevant for Ukraine, this topic is relevant for EU countries, this topic is relevant for United States. Hakan, what is the experience in Turkey?
Thank you so much. I'd like to thank you also for inviting me to this wonderful organization, a very informative organization. As you mentioned, I want to talk about Turkish competition authorities' experience in two subjects. One of them is cooperation with sectoral regulators. Turkish Competition Authority established in 1997, and since then we have many ups and down relationship with other sectoral regulators. And the most important of these sectoral regulators that we have dealt with are Energy Market Regulatory Authority, Information and Communication Technology Agency, which regulates telecommunication sector, and also Banking Regulation and Supervision Agency, which regulates banking sector. I said that we have ups and downs with in terms of relationship with these authorities, but finally we have some conclusion we concluded our relationship with those agencies, and I want to draw the framework of our relationship. First of all, how do we interact with each other? Sectoral regulators ask about their legislation before they come into force. They come and ask to us whether is it coherent with competition law or not, and we tell our opinion to them. Also, the Turkish Competition Authority also shares its important cases related with those sectors with those sectoral regulators before they are decided. In this respect, we have memorandum with two of these sectoral regulators. Also, Turkish Competition Authority asks to sectoral regulators about its important decisions before they come into force. And one more thing, some decisions in the past, Turkish Competition Authority refused to give decisions about in those sectors because Competition Authority said that it's in the area of sectoral regulators, so I don't have to give decision. It's not my job. But Council of State said that whether it's regulated by sectoral body, Turkish Competition Authority has to handle the case if there is infringement of Competition Act. So from after that decision, we started to look all the sectoral regulators, all the infringements in the sectoral regulators area. But I want to mention one negative example. We have very good relationship at the moment with sectoral regulators, especially with three of them. I want to mention a negative example that is related with pharmaceutical industry. I know that Ukraine has special importance in this pharmaceutical industry, and we shared information with Ukrainian AMCU. We prepared very comprehensive and informative sectoral report about pharmaceutical industry with my friend Mr. Atipoğlu, who is also here in here. We studied, we worked on it for 3 years or 4 years, I don't remember exactly, but we finalized it in 2013. But we made many detailed analyses and also stated about structural problems in pharmaceutical industry. But Ministry of Health, which is the regulator of the pharmaceutical industry in Turkey, almost disregarded that report, and they don't said any word about our report. So this is the negative example. Maybe it is not the priority of the Ministry of Health. The competition law is not competition policy, especially competition in pharmaceutical industry is not the priority of Ministry of Health. So I think we have to inform them better, or we have to work on this subject much harder to bring competitive looking for Ministry of Health. The second subject I'd like to talk about the leniency programs, leniency program experience of Turkish Competition Authority. As you know, I thought that I would have much more time to talk about it, but so I started from what is cartel thing. But I'm going to skip this thing. You know, cartels are bad organizations, and there are different types of cartels. But you know, detection of the cartel is getting more difficult in every time because they know much about the prosecution methods of competition authority. So why do we have difficulty? Cartels are not easily observed. Victims of the cartel don't know much about cartel formation. Cartels also operate in secret, and also cartel members are very powerful and intelligent, and they have lots of resources to invest on not detecting. Leniency programs, most effective detection tool is leniency programs nowadays. As you know, what does it provide? One of the cartel member comes, confess and reports and cooperates with the competition agency. Why do they do it? To avoid sanctions. Also, they how does it work? They Different jurisdictions, they have different designs, but in generally, if we make general definition, designed to destabilize and uncover cartels by giving full amnesty to the first qualifying member of the cartel that confess and cooperates. Second company gets some discounts in punishment but still face severe sanctions. Cartels raise the report in the idealized world. Cartels creates distrust among cartel members and creates incentive for cartel participants to defect. There is raise the report in theory, and this make this destabilization of the cartel. We believe like that, and it's uniquely suited in fighting cartels in its programs. Also, you need an insider in addition to other stuff willing to cooperate. Requirements for leniency. What do we need? What do we need for leniency program? First of all, it has to end participation. Second, providing full report and cooperation with competition authorities, confession of wrongdoing, restitution to injured parties where possible, not leader or the confessor has to be not leader or originator, and there must be no coercion of others to participate. It has some benefits to enforcers through cooperation of the inside participants, access to documents regardless of local location we get, and access to witnesses regardless of nationality, may provide opportunity for covert operations. Cornerstones of the effective program is to treat of severe sanctions, heightened fear of detection, and transparency. And transparency is very important. Without transparency, it may not work well, maybe. In Turkey, the Competition Act, Article number 16, says that if a firm or a member of the firm, worker of the firm, cooperates with competition authority, they can get immunity or some discount from fine. With this article, competition authority published to one of them is communique of the leniency communique, and after that leniency guideline competition authority. In this, I'm going to talk about little about these articles of the communique. The first Article 4 defines the full immunity conditions for corporations which are in the cartel. To get full immunity, they have to inform competition authority before the preliminary inquiry, carry out preliminary inquiry, and if it is after that, after the start of preliminary inquiry and before notification of investigation report, they can also inform competition authority, but they have to give extra information that the competition authority doesn't have in hand. Also, there is discount from the fines in addition to full immunity, as a decision of by the board carry out preliminary inquiry until the notification of the investigation report, but which are not covered by the provision of related to immunity from fines in Article 4. In this framework, there is 3-stage discount. I don't want to talk much about it, but the second one is better than third one. Third one is better than the others in getting discounts. What do the firms has to submit to Turkish Competition Authority to get immunity or reduction? They have to submit which products affected, the duration of the cartel, name of the undertakings party to the cartel, specific dates, locations, and participations of cartel meetings. Not conceal or destroy information or evidence related to alleged cartel, and it has to end its involvement in the cartel. Also keep the application confidential unless otherwise told by competition authority. Maintain active cooperation until the board takes the final decision. I want to mention one more thing. Also, there is a marker system in Turkish competition regulation related with leniency. I think it's important thing. Other things are related with the application process of managers and employees out of firms. They have also a right to get some discounts or immunity from the cartel participation. Finally, leniency programs reduce fines for cartel members that bring evidence to the antitrust authority. They are important tools to detect cartels and the cartel participation. Providing full report and cooperation, confession or wrongdoing are being not a leader or originator or no coercion of others to participate are general requirement that can be found in almost all successful programs. It is important for competition authorities to adopt transparent, predictable and clear leniency policies to detect cartels. Transparency is, I think, very important thing for the firms applying for leniency. So US and EU adopted leniency programs and revised them several times. So it's not a static process, it's a dynamic process. You always update your regulation according to developments, to fight against cartels. Turkish Competition Authority adopted its leniency program in 2009, which is compatible with European Union and United States practices. But although there are some differences between Turkish Competition Authority's practices and other jurisdictions' practices, it can be said that Turkish Competition Authority has taken a giant step forward to ensuring deterrence, transparency, and consistency by accepting the leniency program. There are some statistical numbers since 2009. As you can see, there are 14 applications, not very desired numbers, but it's not so bad, I think. The applications coming from automotive, bread, education, transportation, salt, electronics, and other sectors like that. 7 of them were related with price fixing cases. 3 of them were bid rigging, and 3 got full immunity from the application. And in 5 cases, several discounts from half to 1/3 were given to applicants. Thank you.
Thank you very much. I think that there are 2 issues that were raised in this presentation. One is the relationship with sectoral regulation, which should be based on a functional separation system by which regulator regulates and the antitrust authorities applies the antitrust rules, even in regulated sectors. And of course, the cooperation is meant to make sure that regulation is pro-competitive, and also to make sure that if the regulator is aware of antitrust law violations, they can report it to the competition authority for action. I think that's very important. And with respect to leniency program, one thing I'd like to add to the very good presentation of our Turkish colleague is that in the EU we make sure that the leniency applicant allows for a targeted inspection, so that the information provided is not only a confession, but is also a tool for identifying the wrongdoings by others. That is, the downgrade that originates from the leniency application should be targeted, in a sense that we should be able to address the concerns and identify the people in the competitor premises where the violation has taken place. So I thank you, and I'd like now to end with Hasan Kakaya that will provide a summing up of
Well, thank you. I'm a little bit in a difficult situation because I feel guilty of standing between you and lunch. So if you all agree, I mean, we can stop here and I can do my summary when you come back. If you give me 4 minutes, then I can do the summary after lunch, before the next session, or we can do it tomorrow today. Yeah, if everybody agree, I feel less guilty. So I'll pass the buck to Alberto. Yeah. Okay, so I'll be very short. I think we've had a very rich discussion, and what I would like to say are the following, maybe 4 cluster of issues. First, we had a very important discussion on what is the meaning of effectiveness, how to measure effectiveness, and there were a number of issues. The question was that agencies should not count the number of fines because they are not there to collect fines for Treasury, not the cases they prosecute, but look at some objective criteria that can either look at the impact in terms of the benefit for consumers, for business, and for the environment. And those can be conducted in very simple procedures that have been adopted by a number of our jurisdictions, including the OECDs. They are not accurate number, but they are very useful. And this can be done either ex post or ex ante. And I think this perhaps. But they are also important for the impact assessment, not only to show the relevance of the agency, but it can also build the credibility for mobilizing additional resources and justifying the use of taxpayers' money for more resources and the role that the agency can have. Now, in the discussion itself on agency effectiveness, at the risk of simplifying, there are 2 sets of concepts about external effectiveness, at least the way I put it in. Both internal effectiveness and external effectiveness. Under the internal effectiveness, I think there were a number of issues that were mentioned. The need to have an appropriate law with clear provisions, with powers and function of the agency, insistence on procedural fairness, and this also was linked to the question procedural fairness not only internally, but we also from the experience of the Czech Republic that it raises questions in international cooperation. When you involve cases cross-border, procedural fairness can have an important element there. The question of independence, I think, has a very important element among the internal requirement for agency effectiveness. And I'll come back to the point that some of these internal have implication for external issues. Adequate resources, the necessity to have highly qualified, to hire and retain highly qualified staff, and have in place adequate schemes for compensation, the need to have transparent processes, including for the appointment of the member of the board, for the commissioners. It's setting priorities, I think, was another element. And here, I think the priorities not only in terms of important cases, but relevant cases. And here, under the question of priority, we heard from the experience of Ukraine, countries as large as Ukraine would have regional offices. The challenge becomes more complicated that if you have national priorities, then regional offices, those criteria might need to be relevant and need to be defined accordingly. So what type of criteria is an issue that could be addressed as well. Protection of the, and then there was a set of discussion about internal efficiency relating to the tools that are important for agency effectiveness. Some of them are called to about the protection of plaintiffs, transparency, confidentialities, and also efficient investigative tools. Some of them relate to surprise element of dawn raids, and also the ability for markers and for information for the use of leniency program, for example, to identify all the members of the parties that will facilitate the investigation. Those are some of the tools that are important from the internal effectiveness. I'm sure I left many of them, but I think some of the important. Now, if we turn to the external element, I think the question of the impact assessment also has an external dimension. In other words, what is the value added that the agency provide to the general business environment? And this, I think, was a very important point that was emphasized by a number of elements to provide evidence based on facts was an element. The second element for external effectiveness is to develop an appropriate advocacy program with regulators, with businesses, with consumers, with other government bodies, and as well as the courts and the judiciary who need to also be at work. Some of these on regulators, for example, we heard the experience of Turkey about designing memorandum of understandings as well as informal cooperation. But the impressions from the discussion was that the relationship is not harmonious, it's not a calm sea. It goes through ups and downs, and depending on the sector, relationship might be sometimes conflictual. The question also of independence, this is what I said, that some of these internal have an implication for externals. Independence has an external dimension in the sense that the agency need to understand what's the meaning of independence, to protect its independence from external interference, but also by providing neutrality in its advocacy and being a neutral advocator in the system in order to have credibility. I mentioned earlier the concept of credibility, of procedural fairness and transparency. Those are also important for the external effectiveness because they build the integrity and the legitimacy of the decision of the agency, and therefore can reinforce the external effectiveness of the agencies. Building capacity of the judges and the courts and other stakeholders is another important element that can also build the external effectiveness of the agencies. Now, we heard a question of international cooperation, and the question was, well, how does the international cooperation fit in with the agency effectiveness? And I think we've heard a very important element that no agency is an island alone. We are all in the same boat and we can learn from each other. And we heard experiences from international organizations, OECD, ICN, ECN, UN, etc. And some of these can be a source for adopting legislative laws and amending them to bring them to international best practices. The working towards convergence, and I think here the point made, I think is very important because convergence in procedures, for example, on merger reviews, can actually increase the effectiveness of cases which involve more than one country. So if countries have divergent systems of certain procedures, clearly the effectiveness, including cartels as well, will be harmful. So cooperation and convergence can strengthen effectiveness of agencies. The same apply to leniency programs and settlement procedures. Now, in addition to this, we've heard on the experience of Ukraine that there were, in the process of reform and all, there have been attempts, unfortunately, to undermine the attempt. There was a discussion. I don't want to make any statement on it. There was a discussion in Parliament whether to reduce the power and the independence of the agency, and some proposal went as far as to maybe learn from other neighboring countries and do away with the competition authority. Unfortunately, none of these take place. So it means that the battle uphill for building the competition system is not won, and there is more work to be done for advocacies. We also heard that there are the reforms in place at the moment, and the judicial reform which will consider what kind of judicial appeal for the decision will take place. Should there be a commercial court, or should the administrative court look at cases, and what kind of issues will they arise? For example, one of the implications for the administrative court is that the reverse of the burden will go on the anti-monopoly, and this might raise more complication for handling cases. Those are the points that I summarized from the discussion, and I apologize if I left some of the other points that were made. Thank you.
Я дуже вдячний пану Хасану за
Mr. Hassan for this summary of second panel discussion. I think it was absolutely perfect. No one can do it better than you. From the perspective of MCU, our approach was represented at the annual report, and it coincides with methodological analysis and attempt of the agency, Competition Authority of Ukraine, MCU, to improve both external and internal efficiency. These two components go hand in hand, and we have to review them from the same perspective. And when we reinforce one aspect, it has the effect on the other. The internal efficiency influences the external efficiency. Is the vicious circle. So I'm grateful to all the participants of the second session for high quality discussion. Also, I'd like to emphasize once again what Mr. Sharunas mentioned. Communication is everything. Without communication with the market, without communication with the business representatives, we know at MCU what are real issues of the business, what are real issues that have the most negative effects on distorting competition, and we need to communicate properly. We need to communicate our activity as transparent agency. We need to communicate the results of our activity properly to the consumers, to explain why we exist, what we have accomplished, and so that we actually earned our money that taxpayers allocated for our functioning. On the other hand, as competition authority, we have some roadmap to improve competition environment strategically, looking systemically at the problems in the market. Thank you very much. We're behind the schedule. We took some of your lunch break and we resume at 4 o'clock. We'll start session 3 on effects of competition law and competition policy on the markets and consumers. Thank you very much.